Hello, everyone. I'm going to speak some Spanish and English during this presentation at the beginning, and after that, Jonathan Drimmer, our main speaker, is going to develop the whole presentation in English, of course, and everyone is going to have the chance to make questions if they want, using the chat in Spanish or English is going to be the same. Let me give you a couple of things I would like to say before we start the conference. I would like to, in first moment, to thank everyone to be joining here. We are almost 100 people, and we are waiting for more during the next minutes. So I know that several people that is involved in this free webinar don't belong to the Argentine Association of Ethics and Compliance, and I want to say thanks for showing today. I would like to share with everyone that the Asociación Argentina de Ética y Compliance is one of the most important associations in terms of compliance in the region, and I would like that everyone would have the chance to go to the websites of the association to know more about what we are doing. We have been working in compliance in Argentina and Latin America for the last 10 years, developing compliance practices and developing different places in which people can join together and talk about for compliance officer challenges. According to this also, we have the certification in ethics and compliance. That is one of the most important in Argentina, with almost 1,000 compliance officers certified locally in Argentina, and I encourage everyone to know more about this in our website. And going through the topic of today, I would like to introduce you Jonathan Drimmer. Jonathan is partner specialized in investigations and white-collar defense practice for the law firm Paul Hastings in Canada, and he has a lot of experience in human rights investigations as a consultant, as a lawyer, and also working inside corporations as compliance officer. And sharing with you these small presentations, I would like to give the chance to Jonathan to, well, add more details if he considers that could be useful. And after that, start with the presentations. In relation with the questions, I encourage everyone to write questions in the chat. We are going to take it, and at the end of each chapter, because the presentation is going to have different chapters, we are going to be picking the most significant and sharing with everyone to discuss these amazing topics we have going ahead. Jonathan, please, you have the word. You can start.
Thank you, Fernando, and thank you everybody for having me. Thank you to the association as well for the great work that you do. As Fernando mentioned, I'm a partner at the law firm Paul Hastings in Washington, D.C. I also wear a number of other hats as well. I'm a senior advisor at the social consultancy BSR. I'm the North American advisor to the Global Business Initiative for Human Rights. I'm a part of the secretariat for the Voluntary Principles on Security and Human Rights. So I have a number of different human rights hats that I wear, and I am the former Deputy General Counsel and Chief Compliance Officer at Barrick Gold. I've worked on issues related to international humanitarian law, business and human rights issues, other kinds of human rights issues for more than 20 years. I've conducted hundreds of investigations, and many of them involve human rights or international humanitarian law. And so today we're going to talk for the rest of the hour about corporate human rights investigations, their similarities and their differences from other kinds of corporate-led investigations, but we are focusing on corporate human rights investigations. And we'll be talking really about 4 different areas. I'll give you a little bit of a background on the kinds of business and human rights issues that get raised and investigated today, and some of the basic principles that we end up following in these matters. We'll talk about getting an issue, receiving the issue, and putting your team together, and some of the unique aspects that surround business and human rights areas when they're raised. We'll talk about issues around conducting the investigation. And then finally, what do you do at the end of a human rights investigation if you're a company thinking about reporting, thinking about remedies, which is an important aspect of the UN guiding principles on business and human rights. And in each of these areas, what I'm going to try to do is point out the aspects that are similar to other kinds of company investigations and the differences that exist when we are talking about corporate human rights investigations. So let's jump right in, and we'll start with our introduction to the topic. So by way of introduction, we are seeing a dramatic increase globally in Latin America around human rights related issues. Awareness of human rights issues has been steadily growing over the last few years, and COVID-19 has brought a tremendous increase in awareness of human rights over the past 15 months. We are seeing new human rights laws introduced every day. We're seeing more and more reports and stories of human rights issues and more issues arising and being raised. You can see some of the headlines on the slide itself. They really span just about every major sector. We see a lot of cases, a lot of issues being raised in the extractive sector, oil, gas, and mining, a lot in technology, a lot in agriculture and food and beverage, a lot in footwear and apparel. But as the headlines show on the slide, there is no company, there is no sector, there is no geography that's immune from human rights issues that get raised for companies. And when we talk about the different kinds of issues, what is a human rights issue for a company? A lot do focus today on labor issues in the supply chain, forced labor, child labor, bonded labor. You also see claims involving land grabbing, harms to indigenous peoples. Environmental claims that create human health risks is also quite common. Security related abuses, either by private security or public security that are providing security services to a business. Human trafficking claims. Issues in technology may relate to privacy. So a variety of different kinds of human rights issues get raised for companies depending on a number of different factors, but each day we do see new reports, new headlines along the type, among the type that you do see on the screen here. And these lead to investigations. So the impacts that companies, to companies of human rights issues are vast. They're very broad. They can include shutdowns. They can include protests. They can include boycotts. Governments can respond to a human rights issue by denying a permit and a license. It can lead to huge problems for companies, its brand, its continued operations. And every day we see new human rights related lawsuits and criminal cases. It very much has the attention of businesses around the world. In some of the cases, you see the headlines there on the slide. While in the United States, we've had cases for a long time, what we're now really seeing is a lot of cases being brought in other countries around the world, and more criminal cases that are being considered and brought against individual officers and employees, as well as against the companies themselves. And some of these are brought where the incident occurred. Others are filed extraterritorially, where the company might be based, where it's domiciled. But the punchline here is, as we have more stories and reports of human rights issues, as we have more potential litigation and criminal cases, and as there are more potential operational impacts and impacts on third parties, we are going to have more human rights investigations. Now on the screen, I've showed you a few different examples of the kinds of cases that ultimately get raised, the kinds of issues that do get raised. The kinds of issues that any given company is going to see is likely going to depend on their sector and their geography, where they operate and what they do. Lots of different issues can arise, but each sector will have its specific set of salient risks, the most significant risks. And it's important to understand these risks will help you put in place processes to avoid impacts, to avoid being an investigation. They also will help inform the investigation that you ultimately conduct. But it doesn't mean, for instance, if one of the bullets isn't, if you're in one of these sectors and you don't see an issue on the screen, that doesn't mean you shouldn't investigate it. It doesn't mean you don't investigate if it isn't a salient risk. It just means that it may not be one of the typical risks that you are used to seeing. I'll tell you, I once had a case several years ago involving witchcraft. It's a true story. Basically, it was an assault on a woman by a group of employees who believed that the woman had practiced witchcraft on another employee, had actually stolen his heart, and the guy wanted it back, as you might imagine. And so the woman was taken to the police station where she was held, and the police then also told her she had to give back the heart. Now, needless to say, the witchcraft wasn't really a salient risk for the company, but it was something that we had to investigate nonetheless, the assault on the woman. So not being a salient risk, not being one of the normal risks, it doesn't mean that you shouldn't look at it. It may mean your processes aren't as strong as you're thinking about addressing it. It may mean it's less likely to have actually occurred. But as you think about your sector, as you think about geography, there are certain issues that are more likely to arise than for others.
And Jonathan, just as a question, when we speak about, for example, witchcraft or things that are more associated to rural activities, how we can perform investigations in that kind of special environments?
Sure. Well, if you're investigating with witchcraft, you should be very careful. That's my first piece of advice. But no, look, the point of the story here is that, when we investigated for an assault on an individual, a group of employees who physically assaulted another employee. And again, part of the reason I mentioned that specific example is, number one, for human rights cases, sometimes you get very different kinds of fact patterns, unusual things that come up that ultimately lead to challenges. But second, and maybe more to your question, Fernando, you have to conduct investigations in settings that may be very different from the one you are used to dealing with. You might have to go out into an environment that's not in a city or near a city. It's very rural, and you have to be able to interview and get information from people who believe in things like witchcraft. That means you have to be closely tuned in to the local nuances. You have to use the right investigators. You have to use people who can gain trust of the people being interviewed, who may, again, come from very different backgrounds from you and have different beliefs from you. So you have to prepare for whatever is going to come and think about the context of the investigation in which it's being conducted. That's the reason I mentioned that story. But to go on, I guess, to the next slide. So as we do think about what is different in the human rights setting, and to start as we move into some of the practical, the background that you're going to pay attention to as you think about a human rights investigation is largely going to come from the UN Guiding Principles on Business and Human Rights. These were adopted 10 years ago. They serve as the framework that guides business and human rights activities, including investigations. They're separated, as you can see on the screen, into 3 different areas: the state duty to protect human rights, the corporate responsibility to respect human rights, effectively don't infringe on human rights, and put into place processes to avoid infringing on human rights, and then the right to access to remedy. And all 3 of these pillars, all 3 of these issues, the state duty, the corporate responsibility, access to effective remedy, they are relevant when we talk about business and human rights investigations, as you'll see in just a minute. The Guiding Principles also defines human rights in terms of leading international instruments, the International Bill of Human Rights, the ILO Declaration, which largely involves fundamental rights at work. And these really do help inform some of the unique areas that relate to business and human rights investigations, as you'll see in just a minute. So when we think about how the UN guiding principles apply to investigations, and I mentioned we will be doing this repeatedly over the rest of our time, to the left side of our screen, you see what is similar between a human rights investigation and what is similar between what we see in most investigations, including human rights investigations. On the right, what you see is different about human rights investigations. So on the left, you know, for the most part, a human rights investigation, like any investigation, you got to figure out what happened, reconstruct the facts, figure out what the story ultimately is, and the root cause, why it happened. You're going to look at a range of different kinds of evidence, witness interviews, you might look at scientific evidence, maybe there's contemporaneous documentation, but you're looking for credible and corroborated evidence, just like in any other investigation. And you're going to consider at the end the range of different risks that exist as a result of whatever it is you find: legal risks, reputational risks, maybe risks in terms of government interaction regulation. So all that is the same in human rights investigations, but some of the issues are really quite different, as you see on the right side of the screen. First, you do need somebody who really understands the human rights landscape to do an investigation. It's a different kind of field. And as the second bullet indicates, you're dealing with international norms. You're dealing with human rights as the underlying issues that ultimately are being investigated, not just company policies, not domestic laws, but international human rights. And third, you know, when we think about human rights investigations, and this is a critical difference, most investigations think about risks to the business. And for human rights investigation, it's okay to consider risks to the business, but under the guiding principles, the investigation should focus on the impact on affected stakeholders, the impact to third parties. So you are looking at effectively what the human rights impact was, as well as risks to the business, which is a different lens when you think about this kind of an investigation. Fourth, the reputational impacts from human rights cases can be much higher than for other kinds of issues. They can harm your brand, they can harm your reputation, they can harm your license to operate. You can wear a negative human rights story for years and years, and frankly, you don't have a lot of friends when you are made out to be a human rights abuser. Human rights cases against multinational companies, lawsuits are very commonly brought overseas. Most cases where you're investigating potential legal risk, cases are brought in that country where it occurs. In the human rights space, something that might occur in a country, Argentina, and the lawsuit may end up in Canada or the US or the UK or somewhere overseas. It's very common in the human rights space, which is also a key difference. Another difference is that often you're dealing with a different kind of institutional or international agency, right? It's not just a domestic government office, but it's also the UN or the International Labor Organization, or there could be an OECD National Contact Point case that's ultimately filed. Different kinds of agencies and actors get involved in the human rights space. When we think about remedies, again, for most investigations, you think about fixing your internal processes. For human rights, you think about remedies for individuals. That's part of what Pillar 3 is, or communities. You remedy the issue, remedy the harm that ultimately occurs. And finally, the last point is for human rights issues, you know, again, we're thinking about impacts on stakeholders. For a lot of investigations, you don't do outside interviews, but for human rights, you're really expected to look at and engage with people who are affected by your business operations. And so you are naturally led to have to think about engaging with affected stakeholders, which is different for most investigations, and it is a challenging wrinkle. It can be, as you'll see when we get to it in just a few minutes. So while there are plenty of similarities between normal investigations with the UN guiding principles and other established good practice, it also has quite a few individual variations. So Fernando, I'm going to move on to the next section, unless there are questions you want to fire at me.
Yeah, we don't have any question yet, so
okay.
I think Paul is paying a lot of attention. Maybe we are going to receive in a couple of minutes. So
okay, fire questions away if you've got them, everybody. So look, let's talk about how an issue comes in and how it's a little bit different. So you're sitting there at your desk, you're in your company, you're minding your own business. How do you come to learn about human rights issues? Some of the ways are really quite familiar, just as with any other kind of issue. Maybe it's a hotline complaint, maybe there's an audit that finds something. Maybe you're doing an assessment, and out of the assessment, an issue is identified. So some of the ways are really quite standard, quite normal, but some of the ways aren't. So you often will have issues that arise because an NGO issues a report or makes an allegation against you. You might have newspaper articles, you might have inquiries from the UN or another international agency. You might have a lender that has an accountability mechanism that gets in touch with you because a community has made a complaint. It could be a lawsuit. I'll tell you, back at Barrick, one of the most prominent cases that we have, we learned about because an NGO got in touch with us. And right now you do have a lot of companies that are being contacted by the UN in connection with their activities in China. So a lot of different ways that things can come out. In fact, just this week, I was talking with someone who on the same day had a newspaper article, a lawsuit, and a government raid around a human rights issue all on the same day. So the way these issues come out can be very different than normal kinds of issues that have to be investigated. But the way that it comes in is actually important in terms of how you approach it and what to do next. So you get a problem, you get an issue that comes in, and you have to figure out now, what do you do? And a lot of companies start, I think good practice is to start by figuring out what do you really have here on your hands? And this is particularly important in the human rights context for this reason. A lot of cases that do come in they don't seem like they're credible on their face. They actually sound like they're quite implausible. You have to figure out what it is you can learn about the issue to overcome that and see if really this could have happened. So for instance, perhaps it's factually impossible. At Barrick, we were once accused of human rights issues in an African country where we didn't have any operations or business dealings. Factually impossible. Do you already know the answer? Often issues will be raised several times, even after the investigation has concluded. So you may have already done the investigation, so you don't really need to look at it again. But in the human rights space, you have to be really careful because you get crazy sounding allegations that come in, and just because it's unlikely doesn't mean it's untrue. Another phenomenon, you often have NGOs who may be very critical of the company, and they've raised issues that in the past have just not been true, or they exaggerate what's really going on. But just because somebody has said something in the past that isn't true, just because you don't think that they're credible, doesn't mean that on this occasion, they're not actually saying something that is right. And just because they are making allegations that seem over the top, you have to ignore the rhetoric and try to see, could what they're saying actually be true? And again, it's an important part of this discipline because you might think there's no way that this could have happened, but the rule of thumb on human rights issues is you have to investigate unless you can absolutely rule out that the underlying issue didn't exist. Not investigating can be a critical mistake.
Jonathan, and under your experience, what have you seen happen if a company doesn't investigate properly these kind of things?
Well, first, if you don't investigate, it can lead to further harms to third parties. You may be committing more human rights abuses, whether it's environmental issues or security issues or discrimination or harassment or abuses. So it really may create a further risk of harm. But it also, because of that, it creates further risks to the company as well. And often what you see is if something isn't investigated and the issue is raised, it then will be raised in a much more public forum, in a much more harmful way, whether it's the newspaper, whether it's a lawsuit. So not investigating not only creates more human rights challenges, it can and often is much more harmful to the company itself. So let's move on. So you get your allegation and you decide you've got something credible. You need to put together an internal team and an external team. And internally, just like a normal investigation, typically these are run by legal or compliance. Typically you want a serious issue, a business integrity issue, or anything that's serious to be handled under legal privilege and protected from disclosure. You also want to figure out internally who has the expertise to help understand the issue, understand the risk, understand the company's processes around them. And again, also understanding the risks to third parties. Could be sustainability, could be a community relations, impact on third parties. Other thing you want to understand is what are the risks to the business, legal and reputational and political operations, et cetera. You can see that in the little box on the right side of the screen. So figure out what kind of internal expertise is really needed to look into it and help manage the issue and do it under privilege. The other thing about human rights cases is they have a tremendous amount of interest from inside and outside stakeholders. So for government relations, for community relations, for public affairs, all of the stakeholders, people who have interests in the company and sometimes shares and ownership interests in the company, they want to know what happened. They want to know what you are doing. So it's always important to keep them informed, map who the stakeholders are, come up with your messaging in terms of how you're going to tell them what happened and what you're doing about it. But don't forget about your internal stakeholders. Don't forget about your board. Don't forget about your senior management. Don't forget about your workforce. Got to come up with effectively keeping people informed about what you are doing as you start to look into this issue, assuming that it has been made public. And one of the questions that companies always have to ask, do you have the right internal resources to do this yourself? For a big high profile issue, companies often need outside PR help. They often need outside investigative help. And so think about what you have and what you ultimately need externally to help as you move forward. And as you do move forward and you think about who is actually going to do the investigation, who's going to go in the field, review the evidence, interview witnesses, there's no right way ultimately to do this. But there are a couple of things that you have to keep in mind in every human rights investigation. Number one, you have to have independence from the incident. Not necessarily somebody from outside the company, but somebody who is independent from the function, independent from the business unit, maybe even independent from the place where the allegation took place. Sites that are accused of human rights abuses generally can't investigate themselves. It's not trusted. You also need people who understand enough about the subject matter, enough about the human rights norms to ask the right questions, to understand the answers, to understand the evidence, and to be able to identify the kinds of issues that commonly go along with human rights allegations, human rights problems when they come up. Because normally when you have a human rights issue, there are other issues that also travel along with it. So you need people who aren't completely new to to the subject matter and new to human rights to look into these issues. So for instance, if you have a human health risk that's caused by an environmental incident, you may have a corruption risk that was associated with your license or with your inspections or something like that. So understanding what goes along with human rights issues is also important as you do pick the right team. You also, as we talked about with our witchcraft example, have to think about investigators who will be able to engage and gain trust, whether it's on a language basis, maybe it's on a gender basis, understanding local nuances. You have to have investigators who can engage with third parties to gather information and gain that trust. And that may mean using people outside of your company, or it may mean people inside your company, depending on who is more likely to be trusted when they do have those conversations. But like any important, significant, impactful investigation, at the end, the process that you choose and the people who conduct it are always subject to challenge. And the biggest way that a case can ultimately be disregarded and the findings be found to be not credible is if you get this part wrong. If you put together a team or a process that isn't independent, that doesn't have sufficient expertise, people are very easy to dismiss whatever it is you find at the end. So it's important to get this one right. Okay, so now we are out there, we are in our field, we are conducting our investigation, we have our independent team, we have people who understand human rights and witchcraft that are out there that are asking questions. So what are some of the key considerations out there in the field? Well, on the left side of the screen, you know, a lot of it is typical for an investigation. It's standard. You're going to capture and review documents. You're going to look to define the scope of the issue. How broad is it? Is it ongoing? Do we have to look to stop the bleeding? Could it be occurring elsewhere in our organization besides this one place where we're ultimately looking? Scope issues, very common in all investigations, including these. Think about who should be involved, who should be recused, all of the typical questions that come up in corporate investigations. But there's a whole set of categories about issues that aren't like normal investigations. So one of the challenges in human rights cases often surrounds scope, because human rights issues are often caused by third parties, including government actors who are ultimately working with or providing support for the company. You see this a lot, for instance, in the security context. If public security, the police or the military are providing security support for your business, and they do something wrong, they use excessive force, they shoot somebody, you can't really investigate the police. Right? The police investigate the police. You can investigate whether your policies might have been violated, but the police investigate the police. So you really have to think about how it is you define the scope of your investigation. In addition, because human rights issues are high profile, because they impact stakeholders, you may get an unusual percentage of parallel investigations. You're doing your investigations, but an NGO is out also doing its investigation, or the government is also out doing its investigation. So, or a community might be doing an investigation. So in the end, you have to think about how to manage your investigation, knowing that there are other investigations going on, and they may be talking to some of the same people that you want to talk to. So that's a different kind of a twist. And then finally, at the bottom, you know, you always have to be careful if you're out looking at a human rights issue. Often they will involve potential criminal activity. And so thinking about how it is, what you do with evidence that you find of criminal activity, it is one of the challenges in human rights issues. A, because do you share it with the police? When do you share it with the police? B, how do you think about protecting witness confidentiality? You obviously need to protect witnesses that you talk to in an investigation, and you want to prevent retaliation. And some of them may expect that you're speaking to you confidentially, but if they give you criminal evidence, you have to think about what it is you do in terms of going to the police.
And Jonathan, according to that, and I think it could be a lot of complex scenarios, but how do you think is better to conduct an investigation if it's a police excessive force case, or if any government agency is like very close to the issue the company is dealing with?
Yeah, I think it's a great question. I think it's really important to make sure that if you are out there and you are conducting an investigation and a government agency is aware of it, that you tell them that you're looking into it, and you are upfront with them in terms of what you'll share and what you won't share. So you might say, if we find evidence of criminal activity, we'll share it with you. You might say, at the end of the investigation, we'll come and we'll let you know what it is we find. But the one thing you don't want is to be conducting an investigation into a police excessive force or anything else, and have the government come in and basically, arrest your investigators because they are interfering with the state process. So having that kind of upfront dialogue where you're open about what it is you're going to do and your information sharing protocols, making sure they are comfortable with it is smart. It's a smart way to do it. It's good practice. It's a little bit harder if it's an issue that hasn't been publicly disclosed. It's not out in the public domain. That's one you have to think about really quite carefully. But this is an issue that does come up in the human rights space. And this is a classic situation, Brenda, where you have pillar one, the state duty to protect, that collides with pillar two, and that is the company responsibility to respect, right? The state has its duty ultimately to prevent and mitigate human rights abuses. Companies have their responsibility as well. And we're both are looking at an issue is where you can get that tension that comes into place. It's a great question.
Thank you, Jonathan.
So next, on witness interviews, we've talked about this a little bit. And I'm not going to go through every bullet here. But look, when you interview human rights victims of human rights abuses, it requires a lot of care and a lot of thoughtfulness in a way that some other corporate investigations don't. You may need non-traditional interview approaches. You can't just necessarily send in a typical investigator to interview a victim of a human rights abuse. Again, you need people who are going to gain confidence and trust with that particular witness, that particular potential victim. The UN Guiding Principles also talks about the importance of confidentiality. We talked about that on the last slide, depending on whether their identities ultimately ought to be protected for safety and confidentiality reasons. You also do need to be careful about seeking information when you're looking to get information from third parties. Like on the one hand, again, we talk about the importance of interviewing affected stakeholders, which is something that's expected under the guiding principles. But on the other hand, if it isn't really known that you're out conducting an investigation in the first place, all of a sudden, this can expose you to different kinds of legal risks. So you have to think about how to do it and do it effectively, and it requires a little bit of balancing. Nonetheless, the human rights approach says if there are affected stakeholders, you should get their perspective and you should talk to them if you can. Last bullet, though, normally, in any kind of investigation, you document everything. You retain documents, you document everything, but you have to be mindful in the human rights space of privacy concerns. This is true generally. It's not just an email collection, but in the witness interviews and gathering information. And remember, privacy issues are human rights issues, right? So you don't want to inadvertently commit a human rights violation while you're investigating one. So you have to be particularly mindful of the privacy issues, and in part because human rights issues also are so personal that it is an extra consideration in these kinds of matters. All right, last category. We're at the end of the investigation. And you reach your conclusion. And what do? So like a typical investigation in a human rights space, you think about how it is you're going to memorialize your findings. Do you do a report? Do you do an outline? Do you do a presentation? You figure out how to record what you've done and what you've concluded. You got to look at your internal processes and figure out what happened, what went wrong, what should get fixed. You have to think about disciplinary measures. But it's a little bit different on the human rights side for a few different reasons. So first, as we talked about a few minutes ago, the entire third pillar of the guiding principles focuses on remedy. And if a company is causing or has caused or contributed to a negative human rights impact, meaningful remedy to third parties is expected. And you see that at the bottom of the slide with the language from guiding principle 22. And this might mean apologies, it could mean community project, rehabilitation, other kinds of assistance. But you are looking externally to make the situation right with the stakeholders, with the victims that ultimately were affected. So this is different from most kinds of company investigations. And for some of the bigger issues, for a number of different human rights issues that might come out of a historical incident or one big incident, companies do put into place big remedy programs that are designed to provide the kind of remedy I mentioned to the group who are affected. And it's something that we did at Barrick. It's something actually I'm doing again now as an independent monitor for another program in Kenya that came out of an investigation and piece of litigation. So it is something that is unusual in the human rights space. In addition, yeah.
Sorry, Jonathan. And in terms of this explanation you're sharing with us, do you think there are concerns about suggesting legal liability when some kind of remedies could be like applied by the company?
Oh yeah, no, it is. It's another great question. Right? Yeah, absolutely. So when you provide remedy, it's perceived as being some kind of an acknowledgement or admission. And there's a big case going on in the United States right now that involves mining activities in the Democratic Republic of Congo in the DRC, where the plaintiffs are saying because a program to assist in child labor was put into place, that shows the knowledge of the companies that there really was a problem. So it is important under the guiding principles to provide a remedy, but it's also important to think about providing the remedy in a way that's mindful of how it's going to be perceived and that it isn't perceived as some kind of legal admission by the company. So you do have to be very careful about it. But one of the things that's different is when we think about discipline. So in most investigations, when we think about third parties, if a third party, if one of your contractor, does something wrong on site, maybe you just terminate that relationship as part of the discipline and sort of move on. But in the guiding principles, under guiding principle 19, you don't just cut a third party because they might have caused or been involved in an adverse human rights issue. You use your leverage to try to encourage that party to provide remedy and to put in place a program, processes to make sure that it doesn't happen again. You also have to weigh the possible human rights harms of cutting a supplier against retaining them. So it isn't that it has a very careful discussion about what you do if a third party is found to have caused or contributed to a human rights violation, but just cutting it because it committed the violation is not what the guiding principles say. Last point I'll make that's a little bit different here than for other investigations. So you do your investigation, you find that the company actually didn't do anything wrong. But in the human rights space, when you think about remedy, there's often fairly little difference between a perceived impact and an actual impact. For local stakeholders, if they think that you committed a human rights violation, the result can be almost as bad as if you actually did. It can still lead to protests and disruption and boycotts and all of those things, even if you didn't actually really do it. So you have to be very mindful of perceived impacts as well as actual impacts as you think about conveying your findings, as you think about what you do next. And my last slide, which gets to the end of any kind of an investigation, what do you say publicly? Who do you say it to? In most investigations, there really isn't any expectation that you say anything publicly. Normally, you finish your investigation, you report it internally, and that's the end of it. But guiding principle 21 does say you should be transparent to affected stakeholders. So thinking about how much you say, who you say it to, the legal risks around what you say and when you say it, all of that has to be carefully thought about. Reputational risks, political risks, other risks, all of these have to be carefully thought about as you try to be as transparent as you can, while nonetheless consistent with the guiding principles, while nonetheless mindful of the risks to the business. It means you got to think about it carefully. You have to be mindful of your responsibilities and the challenges, just as with the remedy context. But it is a little bit different again in the human rights realm. But that's it in terms of my presentation. Fernando, don't know if we have some questions. We've got about 10 minutes left if we want to take some questions.
Thank you so much, Jonathan. Yeah, we have several questions that I'm going to try to summarize because there are some questions that are very similar one to each other. So first one I have, and I read this question and it's very Argentinian, but if you think in your experience that a human rights claim could be used to exhort or pressure companies on issues related to union claims or political parties that could be involved in regulations or businesses there.
Is a question claims that are basically made in bad faith that are used to pressure the company?
Yeah.
You see that all the time. You do. You see it all the time. And as I talked about before, you still have to look into it unless you're convinced that it isn't true. Just because you think that someone may be raising an issue with a bad motive, you might be right. And I see it all the time. But if they are right about what they say, you have to think about what the nature of that impact is going to be. If a harm is continuing, what additional risks could exist to the business as well. And so, again, you see people raise issues in bad faith. You see crazy things that sometimes people bring up. But unless you can rule out that it didn't happen and you're certain that it isn't true, just because it's not credible doesn't mean you shouldn't investigate, because you should in this environment.
Perfect. And I'm going to summarize a question that is expressed in different ways, but you have mentioned something interesting about that. NGOs is like a new source of information that is useful for companies to understand if there could be some violations to human rights. So when we are thinking about investigations or remediations or all the process that the company is developing to fix that kind of things, do you think that NGOs should be NGOs or universities of that kind of third parties could be or should be involved in some part of that process?
I think they can be. I think they can be very helpful, particularly on the remedy side. I think they can be helpful sometimes even on the investigation side. So it depends on who the NGO is. It depends on the university. It depends on the nature of the issue. But companies often are very smart to involve third-party experts, particularly on the remedy side, to come up with credible processes that will be trusted and implemented locally. Sometimes, if you are out in the field and you aren't trusted by the community for some reason, an NGO or a university might help you in a joint fact-finding mission. So, yeah, absolutely, they can be helpful. They can add credibility, but they could also be very harmful. So I do think you have to be careful about who we're talking about and the specific issue and all of that. But it is always one alternative that's at least worth keeping in mind, particularly in difficult investigations and particularly as you're thinking about implementing a public-facing remedy program.
Okay. And about the best time to share with the authorities an investigation or conclusions, how do you think is best to communicate, especially with authorities that are going to be probably controlling you?
Yeah, I mean, I think you have to be very careful, and hopefully, authorities in countries are used to companies engaging with them around challenges that they have, and they're not automatically going to use it against you, and they are going to give you some level of trust when you come forward to them. But look, you also have to be careful with who you talk to in the government. It might be picking who in the government, which authority, not just in terms of the agency, but what person in that agency you go and you talk to. But yeah, look, going forward voluntarily to talk to the government about an issue before they've become aware of it is something that companies have to think about very carefully, and there are upsides and there are downsides. But again, hopefully by going in good faith and being strategic and thoughtful about who it is you reach out to, they will give you the benefit of the doubt that you are going to conduct something in a meaningful way that again does have integrity and not use it against you. But you can't always guarantee that, which is why you do have to be careful and strategic for sure.
Thank you. And one of the last thinking, Jonathan, that you have like a strong experience working inside corporation in a compliance officer role, but also as a consultant, as a lawyer. Do you think, or do you find different approaches to this kind of investigations depending on the hat you could have?
Yeah, I mean, I think there are different ways. There are always different ways you can go about conducting an investigation, and there's never a single right way. And I think if you approach things, from a community standpoint, you might go with one approach. If you approach things with a pure legal standpoint, you might go another approach. There are a lot of different ways you can ultimately conduct investigations that are credible and that are effective. And then part of it depends on the company, part of it depends on the issue, part of it depends on the local community, part of it depends on other factors, but there are always different ways to go about conducting effective investigations. And it's always, again, what you're most comfortable with and what's going to be best in your mind in those circumstances.
Well, Jonathan, thank you so much for sharing your very interesting experience, and especially to thinking in Latin America market that we are growing a lot and compliance is more important day after day. It's very useful to have that insights from your practice in Canada. So let me say thank you for all the audience here. And well, we're going to be in touch, and of course, probably receiving questions by email. And of course, we're going to try to answer anyone that could have any suggestion during the next date. Thank you so much to everyone. Muchas gracias a todos.
Thank you, everybody. And please reach out if you have any questions.
Perfect. Bye-bye to everyone.